Hello, I'm Sachiko Inoue, a Shiho-shoshi lawyer in Kobe, Japan. Shiho-shoshi lawyer handles inheritance matters. Continuing from the last video, we are going to talk more about the inheritance procedures when a Japanese spouse dies. As we mentioned in the last video, if the Japanese spouse had 2 children, you, as the surviving spouse, is entitled to a statutory inheritance share of half, and the 2 children shares the other half, meaning each child is entitled to a quarter inheritance share. But things can be different if the Japanese spouse left a will. If there is a will, the assets in the estate can be distributed in accordance with the terms of the will. However, in Japanese civil law system, the assets in the estate are not always distributed in accordance with the terms of the will. The assets can be distributed in a way other than what is specified in the will. Oftentimes, a certain part of inheritance assets be reserved or set aside for certain heirs specified in Japanese law. One reason for that is, if the assets inherited by the legal heirs are not enough to satisfy the legally required heir, then the inheritance portion of the heirs designated in the will is reduced in order to meet the legal requirement for legally required heirs. When there is no will or the division of the estate is different from the will, all of the legal heirs must consult about the division of the inheritance and decide who will get what portion of the inheritance. It is important to know that this consultation is not tied to the statutory inheritance share. Therefore, the outcome of this consultation can be different from the statutory inheritance share. It is possible to decide the surviving spouse will inherit everything and children get nothing. These consultations are actually very common, and when it is completed, a document called Memorandum of Division of Inheritance will be prepared and signed by all the heirs along with their personal seals. When the inheritance is made in accordance with the terms of the will, the family needs to prepare 1. A copy of the deceased person's family register. 2. A copy of the heir's family registers. To change the title of the property and close out bank accounts with the will. When the division of the inheritance is agreed, the family needs to prepare 1. A copy of the deceased person's family register. 2. Copies of family registers of all the heirs. 3. Certificate of seal impression. The same seals used in the Memorandum of Division Inheritance. Heirs always need these copies of family registers, the memorandum, and a certificate of seal impression in order to change title of any real estate, closing bank account of the deceased. If you do not have a seal registered by the ward office or city office, it might be easier to register your seal. We, as Kobe Legal Partners Shiho-shoshi Law Office, has handled many inheritance cases that involves foreign nationals. We are happy to help you with any inheritance procedures to support you and your family.